This courtroom starts like any other. Calm judge, polite attorneys, a $1,000 restitution deal. Simple, right? Except in this court, simplicity doesn't last long. What's supposed to be a 5-minute sentencing turns into a full-blown financial mystery. The defendant's here with a check for $1,000, confident everything's squared away. But lurking in the paperwork is a victim's statement that's about to blow that number sky high. Within minutes, we'll go from $1,000 to $8,000, from case closed to see you in November. Watch carefully. This isn't about money alone. It's about communication breakdowns, multiple co-defendants, and a judge trying to untangle what might be one of the messiest restitution disputes you'll ever see. So buckle up, because when a routine hearing collides with real-world accounting, everyone, the prosecutor, the defense, even the victims, walks out confused.
5G713-404.
Good morning, Your Honor. May it please the court. Fellow moving number 85374. Here on behalf of Eastside Holloway.
Stir your name.
Eastside Holloway.
All right. Good morning, counsel. So your client had pled previously to malicious destruction of under HIDA, 200 or more, but less than 1,000. And he was referred for a pre-sentence report. There was also an agreement that he bring restitution in the amount of $1,000 today. Did he do that?
Yes, Your Honor. Yes.
Okay. Have you had a chance to review the report with your client? And are there any material additions, corrections, or deletions? And before I go any further, I do need to inquire. There was a letter sent on October 12th. Is there a Mark Gardner here, a Chris Lamphere here, or a Pietro Vitale here?
Yes.
All right. We need to call in the prosecutor. You guys agreed on 1,000. They submitted a victim's rights statement. Have you had a chance to review that?
And just like that, plot twist. The judge reads the victim's rights statement, and suddenly the numbers explode. $250 in property damage, $300 disposal costs, and nearly $2,000 in lost rent. That's 6 times what the defendant thought he owed. You can literally feel the defense attorney's confidence drain as the math starts stacking up. This is the danger zone in plea deals. Everyone agrees verbally, but then the official paperwork surfaces with real numbers, invoices, and lost income calculations. The victims, by the way, are right there in the courtroom, watching this all unfold. What do you think? Should a verbal restitution deal stand if the paperwork proves the loss was way higher?
Vitale here.
Yes.
All right. We need to call in the prosecutor. You guys agreed on 1,000. They submitted a victim's rights statement. Have you had a chance to review that? Let me read it to you. Call in the prosecutor. I'm going to paraphrase it a little. Pursuant to the Victims' Rights Act, we are submitting our impact statement in this case. The physical damage to property at Gibraltar Self-Storage Unit 3031 129 2640 West 400 West Jefferson has a proposed repair estimate of $6,250. This does not include disposal of damaged parts, a minimal estimate to be $300. So this will be the damage to the partition between units. 2 units were able to be rented due to the damage, creating a loss of income of $110 a month each 9 months of each times 9 months of 1980. Plus, Mr. Muhammad, your name? You guys worked this out for $1,000 in restitution, and I hate to tell you, they're asking for a lot of money. Did you confer with the victims? They're in the courtroom, 2 of them.
So my understanding is, I received a phone call from the defense attorney that's on the co-defendants case. And he actually informed me that there was a restitution amount of $6,000.
Now the prosecutor adds even more chaos. Another lawyer in a co-defendant's case claims full restitution has already been paid. Wait, what? Who paid? To whom? The victims say they've received nothing, so where's the money? This is when you realize just how tangled multiple defendant cases can get. Each attorney hears a different number, a different story, and somehow everyone's right and wrong at the same time. The judge can see this mess forming like a storm cloud. You can tell from his tone, part disbelief, part irritation, that this case isn't ending anytime soon.
Somewhere in that range. And I received this phone call prior to me walking into the courtroom, and he indicated that full restitution was made on that case. So I actually think that we should adjourn today's hearing so we can decipher exactly what happened in the co-defendant's case, because
Come on up here, gentlemen.
you were busted.
Yes, keep on.
Your name, sir?
Yeah, from McNally.
Your name, sir?
Mark Gardner.
Where is Chris Lamphere?
He couldn't be here today. He has a safe answer.
Okay, we don't need to talk about that. I'm sorry about that, though.
Okay.
We got a dilemma because you guys agreed to this $1,000 in restitution. I got somebody here claiming $6,250 plus disposal $300, economic loss $1,980 plus $220 a month.
Yes, and Your Honor, I think that's due to there being a co-defendant. There's other cases associated with this. So there,
How many other co-defendants
I
are there?
believe there was 2 other co-defendants.
6 individuals who were at the scenes.
I saw that,
Medium in charge.
including your client.
Mhm.
Well, I get it, but yeah.
And just based
Have the
on-
other 2 cases been adjudicated?
I don't know about the other 2. I know one has, and that's who called me this morning as I was walking into the court, the defense attorney on one of those other cases, and he indicated that full restitution was paid
By who?
by his client. And that's why I'm requesting an adjournment to come.
I understand. Did you guys receive full restitution?
We haven't received anything yet.
And it might just be with the court. That's why I'd like to just figure out what happened.
And I understand that. Yeah,
To speak to the co-defendants counsel, I get
who is it?
it's Ronald Blood. He's in juvenile court right now in the 3rd Circuit. So how that works is, from what he told me, the prosecutor would only give him a deal in juvenile court if his client paid full restitution. I told him that we owed $1,000. I told him we provided proof that we paid that $1,000. So this prosecutor will subtract that $1,000 from whatever he owed. It's my understanding that he's going around and trying to collect money from all the individuals.
Who is?
The attorney for co-defendants. So
You guys have insurance? Take your
By now, Judge McNally's patience is gone. He cuts through the noise with the line of the day. I don't care if it came from Kim Worthy. That's judge speak for stop name dropping and get your facts straight. The math's now ballooned to about $8,000 in damages, 8 times the original agreement. The courtroom feels like an episode of Courtroom Calculators gone wrong. The judge reminds everyone that restitution isn't just pocket change, it's part of the plea itself. If the amount changes after the deal, the defendant could even withdraw his plea. This is a crucial legal moment. When numbers shift, justice can shift with them.
take your hat off, sir. Do you guys have insurance?
we do have insurance, yes.
What is your deductible?
5,000.
Yeah. I get it. All right. I don't have a problem adjourning this. I hate to make counsel come back, but I think we have to. I'm sorry. I don't,
Is the restitution going to go up? Because that made it for our deal.
well, you'll let me worry about that. Okay. I think the bottom line though is, I don't mean to be critical, but before you set figures for restitution,
The judge, this came from the deputy chief. And
I don't care who it came from. I don't care if it came from Kim Worthy. It doesn't matter to me. The point is, these guys are now submitting a claim for somewhere in the neighborhood of about $8,000. And you've got 3 defendants and you've got one that's pled apparently, and one's in juvenile. And now it creates problems because they're going to have the right, if somebody's going to seek restitution over and above that, I'm going to allow them to withdraw their plea because that was really part and parcel of the agreement. Whereas if it was just restitution to be determined, that's one thing. I'm not criticizing you. I understand a lot more than you think. Let's adjourn this. How long do you think we need to adjourn this?
1 week.
You sure?
Yes.
You don't want to go a couple more weeks, see what happens with the third defendant if he comes in?
We'll request 2 weeks.
All right, let's go, Lisa, to
November 4th at 8:30.
November the 4th at 8:30 in the morning. Okay, gentlemen? I mean, now that I made you come here in person once, I think, right? I don't mind as long as your client's in court with you, but he's going to have, does he have a problem? Do you have a problem? Let me start with you. He was shaking his head yes when I said $1,000 that he seemingly indicated he brought that with him for restitution. How about if I said $100,000 cash bond, assuming he has it? And then we can put it into his name, Lisa, and then that will cover his aspect of the restitution. Fair enough?
Yeah.
Okay, so let's do that. Adjourn sentence November 4th. Defense attorney, defendant can appear by Zoom as long as you're in the same room, counsel, okay? And then, gentlemen, I would still like you to come. I'm going to give you a notice to show up here November 4th at 8:30.
Okay.
I see you have something in your hand, Mr. Pietro, right?
Yes, I just have the court paperwork, and then I have the estimate from the company that originally installed the buildings to repair it, and my impact statement.
Was that all attached here? I think it was, right? So I have that here.
Yeah, you have it.
Okay, good enough. And if you'd like to take a look at it, you're free to do so, counsel. And I'm talking to you, Mr. Muhammad, as are you, Mr. Luigi. Okay,
Want to speak to the victims, without you consent. Have you guys gone to the juvenile court at all? Did you notify the
The juvenile courts today was supposed to be today also. And I originally tried to get one of them changed, and you can't change any of them. It just so happened both of them are the same day at the same time.
well, maybe you can still go down there. Okay, guys, thank you very much. But go down the hall, get your notice. Thank you. Thanks, Mr. Muhammad.
In the end, the judge does the only sane thing, adjourns the case to November 4th. Everyone needs time to find the truth, the receipts, and maybe their sanity. The takeaway here? Never underestimate how one missing invoice or unclear conversation can blow up a courtroom deal. For defendants, that means double-check the restitution before you plead. For victims, make sure every dollar of loss is documented. And for the rest of us, this is courtroom reality. No shouting, no chaos, just confusion that costs thousands. If you found this breakdown as wild as we did, hit like, share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom moments where even simple math can cause major drama.